Now we turn to our last theories of liability under torts, and this is still part of the same cluster of issues that includes nuisance and defamation. All of these torts combined add up to about 9 MBE questions. Next we turn to invasion of privacy. Invasion of privacy is a little bit like products liability in that it is not itself a theory of liability. Rather, it's an umbrella under which sit several theories of liability. And you'll see them listed on the outline. They include commercial appropriation, false light, public disclosure of private facts, and intrusion into seclusion. Let's begin by considering false light briefly. And the reason I want to consider it first is because in the previous video we closed by talking about defamation. False light is very similar to defamation, but technically it is a different tort. Now, to my way of thinking, just about any time a plaintiff will bring a defamation action, he or she also will bring a false light action, because these theories of liability are substantially similar to one another. The difference is, to my way of thinking, false light is a somewhat less serious charge and somewhat easier to make. False light is portraying the plaintiff in a way that is very different from the plaintiff's true persona. And the false light would have to be deemed objectionable to a reasonable person. And malice is required on the part of the defendant in order to show false light, assuming that the plaintiff is a public figure. So we see that false light and defamation are almost the same thing, except false light is an offensive portrayal, not necessarily a defamatory one. And you will see as you get into practice questions that false light and defamation are really quite close to one another. My view is, on a multi-state question, if the alleged statement is a per se defamation, defamation will almost certainly be a stronger theory of liability for the plaintiff than will false light. Commercial appropriation is one of the less tested areas of law here, and it's very easy to spot. So we've got an attractive plaintiff, he or she is photographed on the beach, and then that beach photograph ends up in a suntan lotion ad or something like that, without the plaintiff's permission. Well, the plaintiff is entitled to legal remedies, damages for the appropriation, and also can be entitled to equitable remedies to cease the commercial use of the plaintiff's image or the plaintiff's music or anything else controlled or owned by the plaintiff. Commercial appropriation of a person's image or a person's property. So this area of commercial appropriation is really the only area that sort of touches on what we might consider to be intellectual property or copyright law. These topics are not expressly covered on the exam, but commercial appropriation is. Public disclosure of private facts is another invasion of privacy tort. And here, this tort often is different from false light or defamation, because here the plaintiff acknowledges that the topics touched on by the statements of the defendant are true, rather than opposing them or as false or claiming that they portray the plaintiff falsely. Here we've got private information, typically about sexual habits or medical conditions or perhaps religious views that are closely held and kept private, all disclosed to the public. And again, we require malice where we've got a public figure involved. Finally, we turn to what I think the common, ordinary person, maybe the reasonable person, thinks of when we think of invasion of privacy, and that's intrusion into seclusion. We have a right to be left alone. And when our privacy is invaded by people that want to bother us, to interfere with our right to be left alone, that gives rise to a tort theory of liability. And again, this is a quasi-intentional tort. And what I mean by that is a successful plaintiff may be able to recover punitive damages as well, not merely compensatory damages. Remember that truth is an absolute defense to false light and also to defamation. If we are saying something very harsh about somebody else, but what we are saying is true, well, you can't be liable civilly for saying something that is true, even if you describe it in a particularly judgmental or harsh way. Truth is a defense to defamation, and it is a defense to false light. Of course, at the same time, truth is part of the plaintiff's theory of liability when it comes to public disclosure of private facts. Well, that wraps up a fairly quick discussion of the umbrella of invasion of privacy. Remember, that is not really a theory of liability. Like products liability, it's an umbrella under which sit several theories of liability: commercial appropriation, false light, public disclosure of private facts, and intrusion into seclusion. And that brings us to the last series of torts that I want to discuss, and these are the torts relating to business. So here we see the law of torts touching the law of contracts. And by now, I think you've got a fairly clear idea of just why it is that I think it's a good idea to begin by studying torts. Torts is a very manageable body of law, but we see that it also touches on real property, constitutional law, and now the law of contracts. And the reason why tort and contract law are so important where they touch is because of remedies. A plaintiff who succeeds in establishing that the defendant has breached a contract is merely entitled to compensatory damages. But a plaintiff who is able to establish a fraud is entitled to punitive damages. And that's why many contracts cases have an element of fraud pled, because if established, the plaintiff can then pursue punitive damages. So let's consider what the business torts are. The most important of these is misrepresentation. And I would say up front, keep in mind that misrepresentation can be either intentional or negligent. And it's an important distinction. Where a material misrepresentation is made carelessly, there is no punitive damages available. And it makes sense. We don't punish people for being careless. We punish them for deliberately doing wrong or for being reckless with regard to the safety and well-being of others. So here, with regard to misrepresentation, if a defendant carelessly misrepresents a material fact, that defendant can't be punished, although obviously an aggrieved plaintiff will be entitled to compensatory damages. So, the elements of misrepresentation. First, there has to be some lie, some misrepresentation of a material fact, not something tangential, but something material. And as we get into contracts, we'll see that making the decision that a breach is a material breach rather than an immaterial or a very minor breach is important, both with regard to establishing the theory of liability, and perhaps more importantly, with regard to establishing the remedy that the plaintiff who is successful will be entitled to obtain. So, scienter, a concept that we will touch on in corporations, business organizations, and securities law, is relevant here, because for a fraud to be affirmative, for it to be a deliberate fraud as opposed to a negligent fraud, there must be scienter, which is, in the business context, the way that we describe bad intent, or willful, knowing wrongdoing, scienter. There has to be not only an intent to deceive, but furthermore, an intent to cause the plaintiff to act on the basis of that deception. And then we have to have causation, justifiable reliance, and then finally damages, which are measured as money losses. And those money losses can either be the loss of profit in a transaction or the loss of a prospective advantage which was surrendered as a result of the defendant's fraud. And you'll see plenty of fact scenarios that touch on different wrinkles of this basic idea. Basically, the defendant's not allowed to cheat the plaintiff. That's what's going on here. And this body of law also is worthy of review because when we get to criminal law, the next topic, if you're doing this material in the order I presented, we'll see that the criminal law discussions of the property crimes involving larceny, of which there are quite a few, directly dovetail the tort law of misrepresentation. It's very much the same basic elemental setup. And we're also judging the intent of the defendant along very similar paths. So, after we consider misrepresentation or fraud, by far the most commonly tested of the business torts, we turn next to intentional interference with contract. And this is another area where the law of torts and the law of contracts sort of brush up against one another. We'll see plenty of fact patterns in which a plaintiff has viable theories of liability, both in torts and in contracts. And intentional interference with contract is a tort theory of liability, not really a contract theory of liability. In order to be successful, the plaintiff has to show, number one, that there was a pre-existing contract, that the defendant knew about this pre-existing contract, and that this third party intentionally meddled around with the contract between the plaintiff and the defendant. Now, as one who is typically a defense lawyer, let me say that there is one typical defense offered to the interference claim, which often is a viable defense, and that is this: the free market and competition. We're allowed to compete for other people's business, and we're allowed to compete on the basis of price and on the basis of service. And there is a somewhat gray area between aggressive competition in the marketplace and tortious interference with contract. So the way to tell the difference typically on the bar exam or in a law school exam is where there are plenty of facts that tell us about what the defendant knew of this relationship between the plaintiff and the plaintiff's third party that the plaintiff has contracted with. And there will be facts about some plans to disrupt that agreement, as opposed to the more general competition where we in the marketplace promote ourselves, denigrate, or otherwise put down our competitors in the marketplace and seek to build our market share. Also, the intentional interference alleged by the plaintiff has to prove damages. The plaintiff has to show not merely that the defendant was out there trying to interfere, but that the defendant did successfully interfere. Similar to interference with contract, but a little different, is interference with prospective advantage. So where we've got a contract that is executory and performance is in the future, it is possible that the defendant can interfere with the possibility of advantage, which falls short with totally interfering with a contract. You'll see that the way this is tested, particularly on the essays, the plaintiff will allege both, and may in fact be able to prove both. They're not mutually exclusive, but they are somewhat different from one another. Then we can consider, related to the business torts, wrongful institution of civil proceedings, the torts that involve the use of the judicial system as a weapon rather than as a way of resolving disputes. And the two types of abuse of the legal system are malicious prosecution, and remember that the government is immune from malicious prosecution. Only civil plaintiffs can pursue civil defendants for malicious prosecution. And abuse of process, which is the abuse of civil proceedings. Look to malicious prosecution. You'll see in the outline there's a series of elements, just as we will do with all of the various torts. On an essay, we'll try to narrowly and specifically focus on each element, tying facts from the situation in with the analysis before we reach a conclusion one way or the other. Abuse of process involves some mistreatment of the defendant through the civil courts. And here is where the law of torts ever so slightly brushes the law of civil procedure. So when your professors or your older colleagues said that the law was a seamless web, this is what they're getting at. The law of torts allows us to look at the law of contracts, the law of property, constitutional law, a little bit of the law of criminal law and procedure, all wrapped up in one subject. And as you'll see in the following video, there is plenty of room in torts for us to sharpen our understanding of what may turn out to be the most important subject on any bar exam, remedies.